with voiceover for the Criminal Justice Program Criminal Procedure, course code CJS 31501. The PowerPoint pages that we'll be discussing today deal with confession and the privilege against self-incrimination. We'll see where this particular constitutional rule goes. First section here, Introduction to the Fifth Amendment Privilege. Fifth Amendment is part of the Bill of Rights, the first 8 amendments particularly, and part of the Fifth Amendment says that no person, and indicate here that it does not require citizenship, no person shall be compelled in any criminal case to be a witness against himself, and in today's language, or herself. Not added, but one can assume that it's there. The general theory of the Fifth Amendment and its predecessor concepts came out of part of the Enlightenment and made its way into the Fifth Amendment in 1791 when it was ratified. This theory is that a person has a certain amount of autonomy that shouldn't be breached by a government or anyone else, and a government has the power to do many things to an individual. So in this case, a government shall not require a person to assist in his or her prosecution with any testimony, and we can probably say oral testimony, that would help convict that individual of criminal activity. And so in this particular context, it respects the individual as an individual. The introduction continues. The Fifth Amendment has been determined in a case called Malloy v. Hogan. We'll look at that a little bit later here during this first section here. The Fifth Amendment applies to the states in their criminal practice, and part of that came from the concept that the 14th Amendment has a due process clause that is deemed to require fundamental fairness, and fundamental fairness requires that a government not tell someone that you have to help us convict you. And so the rationale here is the 14th Amendment's due process clause requires the Fifth Amendment privilege, or at least the portion of it that we call the privilege, to be incorporated against the states, and therefore the states must abide by the Fifth Amendment, at least this portion of it, even though it did not have to, or they did not have to collectively. The privilege against self-incrimination helps assure the reliability and truthfulness of evidence, or it is often said so. However, one can certainly understand that removing some evidence from the trial by not requiring a defendant to give it may twist reliability somewhat, and may be untruthful in the sense that an absence of evidence may make other evidence look different than it would be without it. So in theory, we like to see a criminal trial that is truthful, and we think it's a reliable concept, but there can be challenges to it. Coerced testimony may not also be truthful if we did not have the Fifth Amendment and could produce coercion against an individual. People who are motivated to talk based on pain or mental strain or actual physical torture, perhaps a combination of the two, could well be false. Most people will tell an interrogator anything he or she wants to hear, given enough motivation through mental or physical pain and strain. Section 2 deals with the concept of the Fifth Amendment and its original intent. Most clearly, the framers of the Fifth Amendment, made effective in 1791, intended it only to apply to the federal government. There was, of course, this concept that this large, massive federal government, massive for its day, would overreach individuals, and individuals did not have to worry about that from state governments because people were closer to their own state governments and could make sure and assure they would not become tyrannical. But this distant federal government might have different views of this. So we applied the Fifth Amendment to protect we as individuals from the central government, that is the federal government. This privilege, of course, only covers testimonial evidence. It does not cover physical evidence, and we'll speak more about that in just a little bit. In state cases prior to 1964, the privilege against self-incrimination depended upon state constitution, state law, and the legal interpretation by state courts of those rules. We did not look to the Fifth Amendment in the U.S. Constitution to decide the relative merits of forcing somebody to testify against himself or herself. Section 3, privilege against self-incrimination. What evidence is actually excludable under this? General rule is evidence obtained in violation of the privilege is excluded from use at trial. So the defendant does not have to testify, can absolutely refuse to testify, and in fact cannot be asked to testify or called to testify by the prosecution. Similarly, constitutional rights are waivable, and a defendant may testify if he or she so chooses. But this decision to testify against oneself or to take the witness stand and testify in favor of oneself must be the defendant's decision, and it must be based on a free and voluntary decision without coercion. Coercion makes it involuntary if it is officially denominated as coercion. So evidence obtained in violation of the privilege is generally not usable for any purpose. A little history: the 14th Amendment and the alterations it gave. In 1868, subsequent to the war between the states, or the American Civil War, the 14th Amendment was adopted by Congress, and errant states had to ratify that as a condition of readmission, and most did. There was some difficulty getting some northern states to ratify these post-Civil War amendments, of which the 14th Amendment was part. The concept of the 14th Amendment, among other things, with the concept of due process, required that states had to treat people within their borders with fundamental fairness, whether citizen or not. The states had to be fundamentally fair when official state activity dealt with individuals within the states. The amendment, of course, was not intended to gather the first 8 amendments within the concept of due process. This mostly did happen through a concept called selective incorporation, meaning various court cases would incorporate one or a different or a third or fourth or fifth right of the Bill of Rights, would incorporate them into the concept of due process. Fundamental fairness, it is thought, encompasses the privilege not to tell on oneself. So in the court case coming up, Malloy v. Hogan, the U.S. Supreme Court incorporated the privilege against self-incrimination of the Fifth Amendment into the due process clause of the 14th Amendment, and made, in effect, the Fifth Amendment applicable against the states. Section 5, required production of non-testimonial evidence. It's not just any sort of thing that might help incriminate someone that the Fifth Amendment regulates. It regulates testimonial self-incrimination, meaning that non-testimonial self-incrimination may be required, and indeed it is. The prosecution may insist that the defendant give up certain non-testimonial evidence. Real evidence, which means evidence that has physical essence, and other physical evidence is not considered testimonial. For instance, the person's fingerprint is not considered testimonial evidence. Blood alcohol content is not considered testimonial evidence. A firearm would not be considered testimonial evidence, even if it were owned by a defendant. So real and physical evidence is not considered testimonial evidence. Included within this evidence that's not considered testimonial would be DNA evidence in the modern world. Again, succession of Section 5, required production of non-testimonial evidence in the Fifth Amendment. Private business records that an individual or a corporation might keep are not covered by the Fifth Amendment privilege. And indeed, since it's not considered testimony, a defendant must give up blood, fingerprint, evidence from the inside of a swab of his or her mouth, urine samples. The defendant also has to allow himself or herself to be measured, weighed, photographs taken, voice and handwriting samples can be required, DNA samples can be required as well. So these are simply physical facts related to the defendant that are not considered testimonial evidence, and they may very well help convict a defendant. The case in point is Schmerber v. California, a 1967 case, and in this case the U.S. Supreme Court held that a defendant can be required to give a blood sample, and of course by reference and inference, similar evidence is not considered privileged under the Fifth Amendment. This particular case, Schmerber v. California, I misspoke, 1966, not 67. The case arose out of a driving auto injury accident, and the defendant was subjected to a blood draw against his will. and that blood draw was subjected to scientific analysis and revealed that he was driving under the influence, and he argued that to use that against him at his criminal trial made him testify against himself. So the issue in the case is blood alcohol content information privileged because it violates the self-incrimination clause of the Fifth Amendment if it's used against an individual who gave that sample. And the court held no. The rationale was that blood alcohol content is simply a physical fact. It's a scientific fact. Whatever level it is, and the defendant's not forced to testify. He or she does not have to take the witness stand and give oral evidence against himself. Therefore, it is not testimonial in nature, and it's not derived from communication forced from the defendant's own mouth, maybe from his own veins, but not certainly his own mouth. So in this particular context, the use of blood evidence as a physical fact is not considered testimonial in nature and therefore completely admissible. In other words, it is not excluded by the Fifth Amendment privilege against self-incrimination in a federal case or due process clause of the 14th Amendment in a state case. Section 5 continues with the required production of non-testimonial evidence. It has been held that it's permissible to force a defendant to model clothing. Justice Holmes noted this, that the Fifth Amendment prohibits using physical or moral force to extort testimonial communications, but simply forcing one to model clothing, wear a hat, and in one case wear tape under his eyes as the original robber actually wore does not violate the Fifth Amendment privilege. And in fact, in a case involving organized crime, Mr. Dionisio was required to give a voice sample to a grand jury and to the prosecutor. He was reluctant to do this because he knew that the grand jury would compare a wiretap with his own voice and might well match it up, and that might help convict him. So he was more concerned about mob individuals who might be unhappy with him for giving a voice sample, and therefore he was reluctant to do so, even though he had been given immunity from prosecution to do that. The concept of a roadside videotape or a DVR of an impaired driver is also not considered testimonial. So if a driver is stopped from an automobile drug screen or a Michigan v. Sitz type vehicle stop, or a stop because of conduct observed by an officer, the physical impairment of that individual, who might fall out of a car or give slurred speech, simply shows physical facts of the speech or of the ability to walk and motor control or lack thereof. And under Pennsylvania v. Muniz, this does not violate the Fifth Amendment privilege as well. So individuals can be forced to model clothing, wear hats, put tape on one's face, give writing and voice samples, and DVR evidence of the individual's motor skills are not considered testimonial in nature and therefore not prohibited by the Fifth Amendment. An individual may assert the privilege against self-incrimination in virtually any context in which the government wants the person to give some evidence against himself or herself and the individual chooses not to do so. So it could occur in front of a legislature, it could occur in front of a police officer, a high school principal. The Fifth Amendment could occur in a grand jury context, a trial jury context in which the person was not a defendant but called as a witness. So the Fifth Amendment can be asserted. However, there are some limitations. And one limitation, of course, is that it has no application to businesses. Businesses do not have Fifth Amendment privilege. Corporations, labor unions, and similar legal entities are not generally considered to be subject to the Fifth Amendment privilege and must divulge information, even if it harms that entity and even if that entity is being accused of criminal activity. It's also a limitation that exists. It can only be asserted by the holder and not some third party. So a wife could not assert it on behalf of her husband. Some employee of a corporation could not assert it on behalf of a corporation for two reasons. One, it's a third party, and two, it's a corporation. So it's assertable only by an individual who holds that privilege and not by a third party. It also applies only when testimony could tend to or actually incriminate a person under federal or state law that might later result in a federal or state prosecution. So If there's absolutely no chance of a prosecution, there's no Fifth Amendment privilege. An example here would be where the statute of limitations for the criminal activity has completely passed and a government agent wants to inquire of an individual concerning prior criminal activities for which there is absolutely no possibility of prosecution, either state-wise or federal-wise. There is no privilege. The privilege against self-incrimination is assertable, as noted earlier, in a variety of contexts. It can be asserted almost any time, and certainly any time a police officer asks a question. There are certain indications where a police officer has to warn under Miranda, but an individual has this privilege whether warned or not. If a person's been called as a witness in a trial of some third party and is simply a witness, but that witness's answers might tend to incriminate him or her, that individual has complete freedom to assert a privilege not to testify. The person may be called before a grand jury, as was Mr. Dionisio, and not desire to testify. Mr. Dionisio had to testify because he had been given some immunity and no longer had a Fifth Amendment privilege. But as a general rule, any person called in front of a grand jury who is asked questions, the answers which might incriminate that individual may assert the Fifth Amendment privilege. Police officers who are accused of wrongdoing or suspected of wrongdoing, either illegality-wise or some internal violation of policy, generally may cite the Fifth Amendment privilege against self-incrimination, or if it is not going to be used to prosecute that individual, then the individual may not have a Fifth Amendment privilege. But if there's any chance that the answer might tend to incriminate and there's a possibility of criminal prosecution, the police officer has a Fifth Amendment privilege not to testify. Parolees and probation are similarly in parole and probation revocation hearings have legal rights under the Constitution, including the Fifth Amendment privilege not to testify against himself or herself, and may assert this privilege at a parole or probation revocation hearing. Similarly, a prosecution cannot make the use or the assertion of the privilege costly. So a prosecutor is not allowed to comment adversely on a defendant's decision to use the Fifth Amendment or to assert it. So as a general rule, the prosecution cannot make a clear adverse comment on the failure of the defendant to take the witness stand. For instance, during final argument, a reversible error would most generally occur if a prosecutor said to the jury, "Ladies and gentlemen, the defendant knows exactly what happened in this case, and he has chosen not to take the witness stand and tell you about it or to tell his side of the story." That would most assuredly constitute reversible error. The failure of the defendant to take the stand is simply the assertion of a constitutional right, and if the prosecutor indicates that the defendant should have explained the evidence or should have personally presented a defense, that makes the assertion of the legal right costly and therefore a violation of the Fifth Amendment to comment upon that. And reversible error, as noted, would be the most likely result. If a prosecutor could comment on an individual's decision not to take the witness stand, that factor could largely hurt the defendant's case. It hurts the defendant's case in a variety of ways, and it may hurt the defendant's case in any event, but as a general rule, a defendant can ask the judge to give a jury instruction that it should take no adverse reaction from a defendant's failure to testify because the defendant has a constitutional right not to do so. Otherwise, the jury might, on its own even, infer guilt or some level of responsibility based on silence, and that would most assuredly frustrate the concept of the individual's autonomy and frustrate the concept of some of the Enlightenment principles that have informed the development of the Fifth Amendment. This ends the first section of the PowerPoint pages with audio for this particular chapter.